Good morning, ladies and gentlemen. Please allow me to ride on the protocol that has already been observed. My name is Bianca Maere Masukume, and I'm a senior project lawyer with Women in Law in Southern Africa. Thank you to our director for taking us through the Medical Services Bill. I think this has taken us much of the time during this year on working on the bill and the issues that we wanted to be addressed in the bill. As you can see, my presentation, you have already gone through it. I think you noted, I think they went to the end and I was cringing whilst I was sitting there like, okay, what am I supposed to talk about now? But anyway, I'll be quick since I think our 30 minutes is already up. So I think we all know of the Termination of Pregnancy Act. This is chapter 15.10. This is a statute that was enacted in 1977. I wanted you to take note of the year and maybe just look at where we are as a country. We are still being governed by a 1977 law. And so it provides generally for the termination of pregnancy in Zimbabwe, or what we call abortion. But we have the Constitution, which the speakers who came before me have already highlighted that this is a progressive constitution. It provides under section 76, subsection 1, that every citizen and permanent resident of Zimbabwe has the right to have access to basic healthcare services, including reproductive healthcare services. So our interpretation of that is that, once this right is provided, that one has a right to reproductive healthcare services, that should also include a woman, who wants to access, abortion services. That's her right. But currently our law is restrictive on that. So I'll go on to state, the grounds. I think most of you will know that Section 4 of the Termination of Pregnancy Act, it states the grounds or the basis upon which the pregnancies can be terminated lawfully under the law. So the first one is where the continuation of the pregnancy so endangers the life of the woman concerned or constitutes a serious threat of permanent impairment of physical health, that the termination of pregnancy is necessary to ensure her life or physical health. So generally it's just saying, when a woman's life is at risk, then, the law can intervene and allow her to terminate the pregnancy. The second ground is where the child's health is at risk. Maybe they will suffer from a physical or mental defect. That's the second ground. Thirdly, where there's a reasonable possibility that the fetus is conceived as a result of unlawful termination, unlawful intercourse. I'll explain on this. This is when there is rape. I think I'll explain this later on what they mean on unlawful termination. Okay, so that's the next slide. So section 2, subsection 1 of that same act then describes what unlawful intercourse is. This is rape other than rape within a marriage and sexual intercourse within a prohibited degree relationship other than sexual intercourse with persons referred to in section 71 of the Criminal Code. So as you can see, it's excluding some unlawful sexual intercourse. What comes in mind is, marriage. In marriage, married women can be raped. So that means, if you're a married woman and you ask for termination of pregnancy and say that I was raped, you are not covered under section 2, subsection 1. So the effect of this, even for young children, I will take you back to 2020, the Kawenda case. I think we all know it. May I have a show of hands? Yes. I think it's just one person. Do we know the Diana Kawenda case, that constitutional court judgment? Yes, the groundbreaking judgment. So let me just give a summary. The lady approached the court, and that's then when they paid, the 18 years and stated that 16 years, the age of consent should be raised from 16 to 18 years. I think the previous speaker spoke of this. So now you cannot consent to sexual intercourse. The court found that you cannot consent to sexual intercourse when you are below 18 years. So that's the case I'm referring to. That whatever sexual intercourse that takes place when you are 18 years and below, it's unlawful. But then when you go to court and I want to get a termination, then you'll be told that you are not covered under Section 2, subsection 1. Am I moving with people? Okay, all right. I'm afraid to go over when people are not understanding. So yes, I think that was the basis for our application. We were challenging Section 2, subsection 1. I think Ms. Chirisa spoke of this before, that WLSA approached the court to ask for, this ground to be expanded. So in that case, the one that's coming out, it was handed down on the 22nd of November, so it's still a bit new. As you can see, we had approached the High Court as challenging the constitutionality of Section 2, subsection 1 of the Termination of Pregnancy Act. The court then found that this provision is unconstitutional and invalid on the grounds of discrimination against, the people I mentioned before, married women and children under 18 years. So, this is a positive step in protecting body autonomy of women and girls and the fight to decrease safe abortion, which is a leading cause of maternal deaths in Zimbabwe. I think you're too quiet. I thought you would clap hands. Can't you see that this is a win? Yes. You see, that's why I was scared of going ahead with my presentation, because I feel like I've lost people somehow. Okay. Thank you so much, yes. So I then thought that when I mentioned that, that's what the court held, you applaud with me and be happy. Okay, so those are the case references. It was Women in Law in Southern Africa and Talent Forget versus the Ministry of Health and Childcare, the Parliament of Zimbabwe, and the Attorney General. And that's the judgment number. It was ended by Honorable Takuva J on the 22nd of November, 2024. Yes, thank you. So the key findings, I'll just run down this because most things I think I've spoken about it. The court found, that this Section 2, subsection 1 is a breach on Section 56, subsection 1 of the Constitution, because, like I said before, there was discrimination. You can't say that unlawful sexual intercourse covers this person and leaves out the married women or the children below 18. So yes, the court found that it was a breach of Section 56, subsection 1. The court also found that it fails to protect Section 81, subsection 1E, which provides for the right of children to be protected from economic and sexual exploitation, from child labor, and from maltreatment, neglect, or any forms of abuses. So this form of abuse also includes sexual abuse. So now, we are now saying that the TOP Act, the court now held that it is unconstitutional and children should be protected. So anyone below 18 who falls pregnant, remember in the Kawenda case, that sexual intercourse is unlawful. So then they are now covered. I don't want to say they are now covered. The effect of the judgment is that they should be covered, in terms of the abortion. So anyone who gets pregnant below 18, I think this is good to prevent teenage pregnancies. And a mother who is 15 years, who is 14 years, they cannot look after another child if they are still a child. Thirdly, it fails to protect Section 81, subsection 1F, which provides for the right of children to education, healthcare services, nutrition, and shelter. I think you all agree with me that any child who then gets pregnant and is married off, their chances of going back to school are quite slim. So at least now we know that, they can terminate the pregnancy and they can carry on with their lives and maybe learn from their mistakes. Fourthly, it fails to protect the right to human dignity provided in Section 51 of the Constitution. I think you all agree with me. I think that is clear. Then subjecting children to child pregnancies without a right to safe abortion is abuse and torture in violation of Section 53. So the Constitution agreed with us and said that, it is torture, it is abuse and torture to subject a 13-year-old to carry, yes, a 10-year-old to carry to full term, the 9 months. I think I have a testimony. No, it's not a testimony. I think I'll speak to that. I'm a mother of one. I gave birth last year, but I told myself, hey, I'm not going back there again. But I'm 30 years old. So imagine what a 10-year-old, how they will go through all that. So that is torture for a child, and at least the court agreed. The court also took note of international instruments like the 1959 Declaration of the Rights of Children and the Convention on the Rights of Children, and putting the best interests of minor children ahead of any. Like I indicated, the court took note of the case of Diana Kawenda and also M. and Another versus Ministry of Justice, Legal and Parliamentary Affairs. I think they had the same effect. So in the Kawenda case, the court accepted the unlawfulness of any form of sex with a minor person. I think I'm about to finish. So the implications, I think you agree with me that this is a win. Am I right? Yes. So as women, as girls, and those advocating for women and girls, generally, I think this is a win for us. Yes. But then, I think you agree with me, you have seen on the social media that people have different views on this. So we've been a bit quiet on this. I think you know that from 22 November, there's a 14-day period that the High Court gives for anyone who is interested to challenge that ruling. So we're still waiting for that a bit because, we know the noise that's happening already. And after that 14-day, our next steps are then to apply to the Constitutional Court to have confirmation of that judgment. So yes, we are celebrating, but it's still a journey, and I think I implore on everyone in here to support our judgment, give a narrative. I think there are really big people in here. Make whoever you come across who is talking, a different point of view, give them this view, give them where we are coming from and how positive this is. As WLSA, we are still working on this TOP Act. We have been assisting those who are arrested in terms of the TOP Act, those who unlawfully terminate the pregnancy, to assist them and represent them in court. So I think so far there's just one case in Bulawayo where we assisted an 18-year-old and we represented her in court. We have also established a network of lawyers from across Zimbabwe who, when they hear a case in Gutu, they alert us and we then engage them so that they represent these vulnerable women. Yes. So yes, I think in a nutshell, this is it. I can see a hand from Doctor. I'll give you a chance to talk. Yes, Doc.
Sorry, I was just making sure that I talk before they take it out. Now I'm talking to Parliament. Yes. The sitting Parliament. I'm told there is, I don't know how far that motion is. There's a motion on TOP that has been sitting on the order paper. Now it needs you to, if you can't activate it today or tomorrow, then bombard the Minister of Justice with questions so that you create a certain narrative to the whole country. Because your narrative will be carried by me. Positive narrative. And imimi mai wena mama what? Call parliamentarians now. Give them information and the question they should take to Parliament. Those who are it out. She has worked so hard for this thing. It's unfortunate. We are glad it has happened somewhere. Please, even if you have no money, tell them we have no money. We are
Yes, thank you. I already feel like a comrade. Thank you so much, and thank you for your time.
honorable guests, esteemed colleagues, and fellow advocates for women and girls' rights and health, traditional healers, members of parliament, former chairperson of the Portfolio Committee of Health and Childcare, Dr. Ruth Laborde, representatives from the Ministry of Women Affairs, Gender Commission of Zimbabwe, I am honored to stand before you today to open this critical endeavor on ending child marriages and promoting universal access to sexual reproductive health services. As we gather here today to commemorate 2025 16 days of activism against gender-based violence, we are reminded of the disturbing of teenage pregnancies and school dropouts that continue to plague our communities. These concerning numbers of adolescent pregnancies, maternal morbidities and mortalities, child marriages and HIV infections amongst adolescents are a stark reminder of the work that lies ahead of us. It is particularly poignant that we are gathering during the 16 days of activism against gender-based violence, a pivotal moment in our annual calendar that underscores our collective commitment to eradicate this scourge. Although this is a time to recognize and honor efforts to prevent and eliminate gender-based violence, especially against women and girls, it is also a call to action to raise awareness, prevent violence, and hold ourselves accountable for the situation that we find ourselves in today as we work towards a future free from GBV in line with global and national commitments. Since the adoption of the Beijing Declaration and Platform for Action, Zimbabwe has achieved notable milestones in promoting gender equality and women's empowerment. The country has made significant strides in enacting progressive laws and policies demonstrating its commitment to creating a more inclusive society. However, despite the progress made over the past 3 decades, we continue to witness alarming rates of GBV, and that at the center of this is the controversial issue of access to SRH services and information for adolescents. But even in the face of these challenges, we remain steadfast in our commitment to ensure that women and girls have access to quality health care, education, and economic opportunities. We recognize the empowerment of women and girls is not only a moral imperative but also a necessary condition for achieving sustainable development and economic growth. While challenges persist, Zimbabwe's efforts to promote gender equality and women's empowerment are a step in the right direction. The country's progress serves as a testament to the power of collective action and commitment to creating a more just and equitable society for all. As we deliberate over the next few hours, I urge you to remember that the issue of child marriages and limited access to SRH services is not a women's issue, but a human rights issue. It is an issue that requires collective effort and commitment of government, civil society, traditional healers, and individuals. I'm confident that through our collective efforts, we can create a brighter future for our women and girls, a future where they can thrive free from shackles of child marriage and with access to quality health care and education. Let us work together to make this vision a reality. Let us ensure that women and girls are empowered to take control of their lives, their bodies, and their future. Thank you so much.